Hello everyone, it's Harry Sherrard here. Welcome to video 10 of my Employment Law Foundation course. Burden of proof beyond reasonable doubt. All sounds a little bit legalistic, but let me explain the point by telling you about a case that I dealt with a few years ago. So an organisation has a lost property office and there's a manager who mans that. An item is handed in. The next morning the owner realises they've lost that property. They come back looking for their item. It's nowhere to be seen. So an investigation is undertaken. It's noted that the item hasn't been written down in the lost property book, which is a part of the procedure, but the investigation cannot really suggest anything else that happened to this item other than the manager who's looking after the office took it home with her that evening. But the employer thought, well, I don't have proof of her stealing the item. I don't have CCTV cameras. I don't have anybody who witnessed it. So I'm not going to dismiss her for theft. But what I will do is I will dismiss her for breach of lost property procedures, not putting the item in the lost property book. Now what they've just done is they've just converted what could be a relatively easy case to defend to a very difficult case to defend, because theft obviously is dismissible. Not following a procedure, not writing something down in a book, that's not really a dismissible offence. But what the mistake the employer made in that case was they applied the wrong test. They effectively applied the criminal burden of proof, and they said we can't prove the case beyond reasonable doubt. Fair enough, they couldn't, but that isn't the appropriate test. The test is reasonable belief based on a thorough investigation. So you carry out your investigation, speak to everybody involved, and if, as was the case in that situation, there simply is no other explanation for this item, or no reasonable explanation for this item disappearing, then we're able to say we reasonably believe that you stole the item, and that is the basis for a fair dismissal. So remember that point. It is an important point. Don't set the bar too high when dealing with a disciplinary matter. Remember, it's not absolute proof, it's reasonable belief based on a thorough investigation. And in the case I've just been describing, that of course was a very serious matter which resulted in dismissal, but the same process applies in a lesser form of misconduct where you're imposing a warning, for example. So again, it's reasonable belief rather than absolute proof. So I hope you found that helpful, and I look forward to speaking with you again next time.